Now to our Supreme Court decisions. The first, of course, was a focus on the Second Amendment. And so I think it's important to talk about the actual words in the Second Amendment, right? A well regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay, well regulated meaning what? Dictionary definitions kind of come around to controlled or supervised to conform to rules, regulations, tradition. Um, and so some level of control, right? The rules and regulations. I believe this is the reason why. And I will mention again, I am a gun owner. I do support the Second Amendment. I do believe we have the right to own them. But I also think that the government does have a right to impose some rules and regulations. I think that comes from just that particular statement, this idea of a well-regulated militia. Okay. Next, we need to talk about what is the meaning of militia. Okay. And there's a couple. A military force that is raised from the civilian population to supplement a regular army in an emergency. Okay. Creating a militia was no answer to the Army's manpower problem, right? This idea that coming from the people. A military force that engages in rebel or terrorist activities in opposition to a regular army, or all able bodied civilians eligible by law for military service. And I think from each of those definitions, we get the idea that militia really does mean the people. Okay. It doesn't have to be this group that is raised from civilian population. It's you're ready when that emergency arises, right? So in order to do that, you need to be able to have the arms, right? So that you can respond to that emergency when it occurs. So I think this is where we get the kind of basis for where we are in America now with our gun laws. All right. In this particular case, New York Rifle and Pistol versus Bruen, this dealt with the idea of concealed carry processes within the state. And there's basically three standards, right? One, constitutional carry. This is allowed in 24 states. This is where there is no process. You do not need a permit. You do not need, you just need to be a legally able to possess a firearm, and you are allowed to concealed carry in those states. Then we have what we call may issue states. Previous to this ruling, there were 8 may issue states. And then the rest were what we call shall issue states. And it is important to note this case was not a case regarding constitutional carry. It focused more on the permit process. May issue basically means that you can meet a standard set to obtain a concealed carry weapons permit. However, there still could be a prohibition. Often in the may issue states, this is based on some sort of demonstrated need that there have been like threats on you or someone that close to you or in your family. Also, sometimes this need can be demonstrated by like maybe you're in a profession where a lot of cash or high value items. If you're a jeweler who transports jewelry and large sums of cash, this is sometimes used to meet that may issue standard of a demonstrated need. Okay, and then of course the shall issue state, where once you meet the standard to be a concealed carry, have a concealed carry weapons permit, then the permit is issued. And so in this particular case, what the court ruled was that this may issue standard went too far. Okay, that you could have a shall issue, that you could have a standard that individuals have to meet. They have to be a legal gun owner. Usually there's some sort of training that's required, some sort of class. There's also fees associated with that. That these things were okay, but that imposing the additional standard beyond that is what was unconstitutional. And so this is going to have impact in those may issue states. And so those states are California, Connecticut, Delaware, Hawaii, Maryland, Massachusetts, New Jersey, and New York. Okay. And although SCOTUS did note that they were okay with states having a process, they did note that because any permitting scheme can be put towards abusive ends, we do not rule out constitutional challenges to shall issue regimes where, for example, lengthy wait times in processing license applications or exorbitant fees deny ordinary citizens their right to public carry. And so basically what the Supreme Court was saying is kind of issuing a warning to these may issue states, right? You may start to try to craft some legislation to impose shall issue standards that really actually themselves become unconstitutional. And if that happens, we are more than willing, the Supreme Court, to hear those cases and to rule on them. So kind of like a warning not to do that. I live in California. I'm actually get a newsletter from Attorney General Rob Bonta. And California is one of the most restrictive states in the country when it comes to firearms. And his response to the ruling in Bruen Californians are committed to safeguarding our citizens, our children, and our future through common sense gun laws. Okay, states still have the right to limit concealed carry permits to those who may safely possess firearms. So, putting forth this idea that things are going to happen, and in California to along the lines of going to this shall issue process, but that they're still going to try to find a way to put in what they call common sense gun laws that may lead to some restrictions, and just see how far they can go without getting constitutional challenges to them. A result I can kind of share locally with this decision by the Supreme Court: concealed carry weapons classes here in California are filling up. A federally licensed firearm dealer I am very familiar with. I have shopped there. I will point that out. Redstone Firearms in Burbank, California. Just a few days after the ruling, their classes for concealed carry were booked through the middle of July. Also, what's likely to come from this Bruen ruling is to lead to some challenges on some of the state's limits on ammunition, gun type, and magazine limits as well. Another point on concealed carry, kind of personally, something that I've experienced. Several years ago, I moved to Atlanta, Georgia, for a short period of time, for about a year, a little over a year. While I was in Georgia, and it still is a concealed carry state. And there was a little bit of a different sense in the air. People were a little more comfortable in some situations where they might have been less comfortable, because there was a sense that there was less crime in certain instances because the criminals didn't know who might be carrying a gun, and possibly it may make you think twice about what you're going to do. And if you look, you can find different anecdotes in West Virginia. Recently, there was I believe it was termed as a mass shooting that was stopped by a concealed carry citizen. I think there's definitely some support for why you should allow concealed carry. And personally, I do think that as long as people undergo proper training and they're responsible gun owners and they obtain their firearms legally, that concealed carry is actually probably not a bad idea. Okay.